some of these cases representing the victims. But this is on a whole nother level, having an AG crackdown. Frankly, I didn't know that was coming. So that was an interesting case. And then, yeah, like I said, title companies were named, law firms were named. And I think the AG felt that all these real estate professionals created a veneer of legality to it all. So yeah, key takeaways, due diligence, look for the red flags, need for internal compliance procedures, thorough title reviews, and staying informed. Title insurance is powerful but not foolproof. Legal counsel can add a layer of protection, and professionals must remain vigilant. I also wanted to go over Phyllis's 9 red flags. This is a tremendous sheet Phyllis brought, but yeah, these are 9 red flags that may expose vacant land fraud. And Phyllis is exactly right. A lot of real estate fraud, including deed forgery, it actually does exist with respect to vacant land because nobody's there. Sometimes it's people that are out of state, the owners, nobody's really looking after it or maintaining it. But yeah, if the seller's willing to accept a very low amount, that's a huge indicator. That was a big part of the AG complaint, that, wait a minute, these transactions were for way below fair market value. So how did the title companies, or how did other professionals bless this? No outstanding mortgages, free and clear property, seller in a rush to close, records show the owner's address is outside the US. Real estate agent never meets with principals and is hired by email. The purported owner is not currently located in the owner's address listed in the county's tax records. Multiple foreign countries involved for one party, and documents sent to the title company already executed without prior inquiry. So this is Stewart Title did a tremendous job. And my view is, yeah, I think all these, a lot of really, really great title companies in Arizona. I think to the defense of the title company, or maybe even the law firm, I don't know, I can't speak for any of them, but some of them might just thought, hey, it's not my job to to inspect the transaction and make determinations on, well, I think this is a little bit below fair market value, so it's not a fair, so there must be fraud. They're not to their defense, they might have thought at the time, we're not arbiters of fraud. But I think what the AG case is now saying is, look, if it's this blatant, you're not allowed to look the other way and still, condone or facilitate you're a conspirator almost at that point. And so, yeah, it's really interesting. But anyways, that concludes today.
So we won't close unless we confirm that it's the correct seller by sending the letter to the address and the tax records, and they have to contact us.
Okay.
If we can't get a hold of them, then the sale's not going to go through. They also, this happens on buildings that are empty as well. So now we put on the letter that we send, there's a number on it that they have to call us and give us that number, so we know we're talking to the correct person. So yeah, it's incumbent on US rosters to make sure that they know what's happening in the transaction. And you're right, when we see a difference, whether it's more that the property is going to be worth, which suggests that something has gone on the property that nobody knows about, or it's too low, then that always creates a conversation between underwriting and the escrow officer.
So if the lender's underwriting buses it, does that persuade your decision from flagging it right away or notifying it?
No, the officer is really the one that
okay. That's the final call then.
Right. So there's just the title, if they see a difference in the value, it's extreme, they'll point it out when they send the commitment to the escrow officer.
Yeah, okay.
You might want to check this out.
Yeah, okay.
And find out what's happening here.
Yeah.
Right.
Wait, so Ben, do you do a lot of abandoned alleyway stuff in Phoenix? I've heard. Oh.
Yeah, we've had a few of those cases, not a ton, but yeah, they do exist.
I have one
Okay.
I just wasn't sure that, the best way to go about it, and then how the easement works, and then, you know, if it expands my, property taxes, or if it's just like a separate parcel on my property. But I'd definitely love to, take over the alley, because it is just a hot mess.
Got it.
There's like a dead end, so there's like bums that walk in and realize they can't pass through, and then they'll walk out.
Yeah.
But there's a power pole there, so I just wasn't sure how like that easement works.
That's where you get all your neighbors to join in and agree to it.
Mhm. Oh, I'm sure they would.
Yeah.
I was gonna say, it sounds like you need a German Shepherd in your backyard.
I have a husky and 6 chihuahuas. I think I'm set.
Question, Ben, on prescribed easement. So I think you said after 10 years, someone can actually petition that they have a right to use it, but that's where you turn your prescriptive easement into a real easement on paper? Is that what you do after 10 years of
Well,
using a driveway? You could
yeah,
actually
good,
record
good,
it.
good, good question. So yeah, you would go to court, and
Okay,
then you record the court order,
okay.
then that becomes,
A recorded real easement.
yeah, then it becomes, well, I mean, it's a prescriptive easement, but it would be a recorded, it would be a recorded one, yeah.
Okay, so
I
it's
mean, the
still
court would award you a prescriptive easement, and then you would record
in writing. Okay. So it goes from non-recorded for 10 years, and then after 10 years, then you could record it. Essentially.
it. Exactly.
All right, there are no further questions. That concludes our lunch and learn session. Thank you, everyone.
Yeah.